introduce ourselves briefly? Well,
Yeah, go ahead.
So my name is Maureen De Silva. I am a partner at Taylor English law firm here in Atlanta, although we have attorneys all over the United States. I've been an attorney for about 20 years. Before that, I was a sound engineer, and I am the current head of the employment team at Taylor English.
and I'm Mitzi Hill, also a partner at Taylor English. I have been practicing for almost 30 years, which really blows my mind. I teach at Emory's Law School and they think I'm so old. And, you know, compared to them, I am. But I'm the head of our data privacy and security practice. We don't have a formal group, but there are several of us who have substantial experience in those two areas. All of us are members of the corporate team at Taylor English, and so we do other things as well, a lot of technology company representation, a lot of startup representation. And many of us got our privacy and security experience by being in-house at corporations before we came to Taylor English, which is also true for me. I was in-house at what was then Turner Broadcasting for about 15 years before I came to Taylor English. So good deal of insight as to what it's like to be in-house in addition to being outside counsel.
Hi, yeah, my name is Linda Yang. I've been an attorney for a few years. So I am in both the corporate practice group and the IT group. On the corporate side, I do a lot of mergers, acquisition, and joint venture, capital raising, and just general business transactions. And happy to be here and meet you all, and hopefully, you know, my presentation will be some more informational for you guys.
Point this thing and see if this moves.
Hold on. Give you try now.
Oh, hang on. This, okay. Excellent. So I help businesses that are based in the US, but also have a lot of European companies, and I have small businesses or medium-sized businesses that I help. So I have a lot of clients who are small startups, and one of the things that they all have in common is they're going to have employee issues at some point. Regardless of what industry you're in or where you are in America, you're going to have an employment issue. And I know a lot of you who might be at the startup phase, you're wondering, how am I going to do all of that? So I'm going to run through that and hopefully give you a high level of some of the biggest traps that you have to be careful of, and some of the key issues you need to bear in mind. So question numero uno is funding. How are you going to pay these employees? And you've got to have a good budget in mind and understand taxes that might have to be paid on top. And the reality of it is that there are payroll laws that vary throughout the United States. And I'll come back to that later. But the takeaway is that payroll laws are not uniform throughout the United States. So where you're based and who you're talking to is going to impact your budget. So as much as people might be on LinkedIn and thinking, yeah, I saw this great person out in LA, and I want to get that person on board, or there's this woman in New York who sounds great, hold your horses a little bit, because you need to get some advice, some tax advice, payroll advice, and legal advice before you start making promises to a bunch of people where, you know, you might have to backtrack because actually it's not within your budget. So, like I said, you should get a good CPA. You really shouldn't be starting to take people on without having a discussion with a CPA. That would be very, very unwise, in my view.
It's a cliffhanger.
That was my presentation.
Yeah.
Yes, thank you, Minori.
Okay, so are you paying correctly? So as I said, I am head of the employment team, and one of the top issues that companies get in trouble over is when they don't pay people correctly, and they say they're going to pay them as a 1099/contractor. And what can often happen is in that startup phase, I hear this all the time, some of my smaller clients will say, yeah, I've got this person, I pay them as a 1099. You know, it's only for a short period, so I'm paying them as a 1099. And I would say, that's not how it works. The law does not look at how long somebody is working for you and say, okay, they're only there for 2 months, I can pay them as a 1099. There are IRS rules, there are DOL, Department of Labor rules, and you're either going to be an employee or a contractor based on pretty much 2 things: how much are you paying them and how much control the business has over what that person does. So that comes back to my initial point. When you start making promises to people or start having dialogues with people that you think you're going to hire, be very careful about going down that road of, I'll just have them as a 1099 and it'll be fine. Okay. And the other issue that often comes up is overtime. Do I have to pay this person overtime? Myth number 2, which I did a Passel post about not that long ago, is I can pay them a salary and then I don't have to pay overtime. Not true. So if anybody's doing that, it comes back to there has to be an analysis of what this person is doing and how much you're paying them. And so one of the other things, the areas that employers constantly get sued over is not paying overtime. So the first one is, are they misclassifying somebody as a 1099? Number 2 is, are they not paying overtime and they really should be? And especially when you start as a startup and you might get folks on board who are doing a lot of hours in the beginning, trying to get things ramped up. Now, there are some exceptions to overtime and certain things like that if you're an owner, but I'm not going to go into too much depth on that. But generally, if you're trying to get other people who are not owners to help you at the initial phase, you have to be very mindful of how many hours you're asking them to work for you. And sweat equity comes up sometimes. You say, oh, it's just sweat, I'm working for sweat equity, or they're going to be working for sweat equity. Again, it's all fine until it's not, and the person gets annoyed and they haven't been paid, and then they go and see a lawyer. And then you might find out as your startup, oh, I actually owe them back pay and overtime. So sweat equity is something you should be very careful about throwing out there as a way to bring people on. You also cannot give people a day off in lieu of overtime as a private employer. So if that's something that you're also trying to offer people, be careful about that. And state law I mention here because just as with payroll, there are different state laws throughout the United States on overtime. There's a federal law, but there are also state laws on when overtime gets triggered and you have to pay overtime. So again, when you're thinking about hiring people in all different locations, there isn't going to be a one size fits all. So please be mindful of that.
So it's the state law where the employee is that counts, not the state law where your business is.
Yes. So some things can apply to both, right?
Nice.
But if you go and hire an employee in California and your startup is registered in Georgia, you go to your office in Georgia, but you've gone and hired somebody in California, that person is going to have California protections. So, and their overtime is different to here. So I'm just throwing this out as a generality. Do not assume that you can just be here and have all these people throughout the US or elsewhere working for you and that you just need to comply with Georgia law. That's not how that works. So I've touched on that already in different states. I also have folks who have made inquiries about hiring people who are outside the US. Sometimes they've had people who used to work for them in the US and then they decided I'm going to move to Turkey or something and I want to carry on working. And the employer usually says, can we just keep them on payroll? There are a lot of ramifications to somebody working outside the US. You may be subject to the foreign law, and it might not be just that employee, but it might be your company as well. There might be all kinds of registrations or regulations that are triggered by you hiring somebody who's resident in another country. And all of this is to say, you just cannot go around and say to somebody, that's fine, go and work in Turkey and we'll pay you as an employee. Even if you say, I'm going to pay you as a 1099, that might not work under local law where that person is living. So I say all of this because COVID happened and remote working became very normalized. Lots of people moved. Some people moved out of the US, people moved to different states. People moved out of cities and decided they could work from a cabin in the woods somewhere. And it's fine if you've researched what you're doing. And it's fine until the person gets, disgruntled, or you have a tiff about something, and that person then goes to see a lawyer. And then you realize, oh, I should have been registered in Oregon, or I should have been, paying taxes in Oregon or something like that. So it's just me reminding you that the world is bigger now because of COVID, but unfortunately you can't avoid researching what your obligations are just because remote working has become easier. Okay. I'm not going to go into detail on trade secrets or anything like that because we have other folks that are going to cover that. But what I would say is the law on restrictive covenants, things like non-competes, non-solicits, and non-solicitation of customers, non-solicitation of employees, that varies state to state. And in some states, restrictions are not enforceable at all, except confidentiality. In some states, you have to allow the person a period of time before they sign a document, a non-compete, in order for it to be enforceable. And if you don't give them that review period, then it's not enforceable. In other states, you have to pay the person a minimum of a certain salary in order for a non-compete to be enforceable. And I have many clients who have a separation between, let's say, the business decision makers and maybe their recruiting folks, the person who's going out trying to find talent to bring on. And there's sometimes a disconnect between them. And the recruiter has discussions with various people in various jurisdictions, and they forget to check what the impact could be on their ability to have restrictive covenants put in place. There is a general movement going on right now in the US in various areas where non-competes are being frowned upon. The FTC is looking into banning non-competes. There is case law even in Georgia within the last year or so, which is making it harder to pursue employees to go to competitors and what they call tortious interference by a former employee or a new employer. So the general trend right now is to make it tougher and tougher to restrict your employees after they leave. So you need to be mindful of protecting your trade secrets as best you can, making sure that you have things in place to protect access to trade secrets. Don't leave stuff lying around, obviously, that everybody can access, because then it's hard to argue that that's truly a secret and something that's very treasured in the company. And so that comes back to how will you monitor in the age of COVID, where a lot of my clients have remote workers? What systems do you have in place to see what they're doing, what access they have online, where they are working? And then the enforcement issue is really, like I said before, if your workforce is in different places. And even if you have a piece of paper that they've signed, how are you actually going to enforce that if they decide to violate what they promised to you? Are you really going to go and sue them, you know, on the other side of the country? What would be the cost of that? So you're going to have to start thinking a bit more brass tacks. How do I protect who has access and who views certain things in a very practical way? Remote working issues. I think this might be the last slide I have. It's probably a good idea to have a policy for your remote workers, and probably 3 years ago, that was not such a standard thing to have in a handbook, employee handbook, but it is pretty advisable and standard to think about that now. You know, where are your employees allowed to work? What kind of security issues should they tell you about? How quickly should they warn you? In some states, you might have to provide certain equipment. In some states, you can't force the employee to absorb the costs of acquiring certain things. So be aware of that in your budget as well. Insurance, accidents can happen at home, so you have to always update your, you know, your workers' comp insurer, because they're working for you, even if they trip over something at home. And the law can differ on that per se, just to make it even more of a headache. And I think I'm going to end with, I think this is my last slide, the administrative costs of all of this. I have many clients who are in the small to medium size range, and I have had to guide them as to not look, you know, go hill and dale looking for candidates, because when you are on a tight budget, those administrative costs of you having 15 employees, but 15 employees who are all in different states, that's going to be an administrative headache for you, legally, tax-wise, compliance-wise, as opposed to you saying, you know what, I'm just going to try and find 15 people to join it. So that's just my personal thoughts on some key issues for startups. I think that's me done.
Well, you're an expert in this thing now, so.
There's only 2 buttons.
Right, so it's not too hard to screw up, apparently. We'll see, right, famous last one. So we're going to talk very quickly about data privacy and security. Mostly this is about awareness raising. And understanding that these are issues that are going to confront every company these days. And there are a lot of bullets on here. I'm not going to read them to you. I thought you might like to have them for reference later. But, you know, in the privacy area, and I guess one of the things I should say at the top is data privacy is a completely different subject from data security. Engineers in the room certainly understand that. Others of us, it takes a while to get that message in. They are related to each other. They are sort of two sides of the same coin. We are in a phase legally where data privacy rules and regulations are driving a lot of security decisions, but they are in fact two completely separate topics. And one of them is more heavily regulated, but both of them can be imposed on you through your contracts with your customers, even if you are not directly regulated. So those are two kind of big overarching messages about it, is you have to think about both of them. And even if you are not subject directly to a law about them, it is likely that you will be required by your customers to be a part of their compliance chain. Essentially, everybody if a big customer is regulated, everybody in their supply chain is going to be required to comply as well. Regulations are common. They, just like in the employment arena, they differ by jurisdiction, and the ones that count are the ones that cover the affected human in general, not the company. And so again, if you are based in Georgia, but your customer or your employee or your business partner is in a jurisdiction that affords them some privacy protection, you have to account for that within your own environment. Generally speaking, over the last half a decade, we have had a proliferation of privacy rules that cover personal information or personal data about individual human beings. This all used to be referred to more than 5 years ago as personally identifiable information, PII. That's not really the going acronym anymore. So if you want to be overdrawn in slang, it's now personal information or personal data, and it is a much broader tool. PII basically meant your name, your driver's license, your financial account numbers, maybe your address, right? Personal information is almost anything conceivable that could identify you, just as PII did, or that could be related to you as an individual. And so it can be your mobile device number, not, either the phone number or literally the mobile device number. It can be your IP address. It can be your photograph. If you've got a photograph in your LinkedIn profile or in your email signature. In California and in Europe and in some other place, Canada, it can be your business contact information is considered protectable personal information. So it is a broad bucket of stuff, and the implications of not treating it correctly can expose you to litigation in some places and to fines and investigation in others, all of which we want to avoid. Those are bad outcomes. Again, depending on the jurisdiction, it may cover HR type data, it may cover B2B type data, or it might only cover consumer type data. So you really have to understand what data your organization takes in, what the sources are, where those people roughly are located, and then you'll understand a little bit more about what frameworks apply to it and what you have to do. Typically, the privacy laws today require you to make certain upfront disclosures. In the US, you generally do not have to have consent to collect or process information from people. In other jurisdictions, you generally do have to have consent. So if you're designing only for the US, it's a little different than if you're designing for something globally. The thresholds are different, the gatekeeping is different. There will also be, so in addition to your public facing or your employee facing disclosures about what you do, you have to have processes that back up what you say you do. We keep it secure, we keep it for this long. Here's what we do with it. We don't do anything else with it. If we're going to reuse it for something else, like this really cool new marketing initiative that's coming out, we'll come back to you for consent. You can't reuse data that you've gathered under one set of assumptions for something that isn't covered by that set of assumptions. A big thing to understand if you're doing anything in Europe especially is that, but in other jurisdictions as well, China is a big one, you may not be able to take data out of that country or out of that jurisdiction or access it outside of that country or jurisdiction unless you have complied with really stringent rules about it. And in the case of some countries, like under Chinese law, you have to register with the government for reasons that have nothing to do with protecting privacy of individuals, in my cynical opinion. And so again, being aware, if you are overseas, do you owe a duty to your workforce to keep their information private? Can you access their information in the US, including their email address, including their payroll data, including their benefits information? You may have to look into those kinds of things. Fines and lawsuits are the common penalties for non-compliance. Non-compliance is not just breach, right? It can just be violating the rules, even if it didn't result in breach. We talked about customer contact tracks may impose these requirements on you. And, again, before about 5 to 6 years ago, we thought of privacy as regulating financial services companies, healthcare companies, interaction with children, and to a certain extent, interaction with consumers. And that was kind of it. Today, everybody, it doesn't matter what business you're in, doesn't matter what vertical you're in, doesn't matter whether you deal with individual human being consumers or whether you are in B2B, everybody is subject to these things in one way or another, or is fast going to be. The EU led the way, the US is copycatting. We don't have a federal privacy statute in the US other than for financial services and for healthcare. What we do have is that California adopted an EU-like privacy model, put their own spin on it, and now we have a dozen states that have passed a similar comprehensive privacy law. and other states that are branching into specialized privacy laws, like governing biometric information. If you use a retina scan, face scan, fingerprint scan, health information, states are passing little mini HIPAA type laws. So it's getting more and more complicated, and it is just like the employment case, it's a state by state thing, and it's not where you're located that counts. It's where the humans are located that count. So that's privacy. Security is, can screw it up. Told you famous last words. Security will remain a mystery, please. Thank you. Okay. This is security largely, as I said, for if you're in an unregulated industry, meaning not healthcare, not financial services. Many companies today, their security planning is driven either by the desire to keep their own secret sauce secret, or because they have privacy obligations enforced on them by law or by contract. The common thing you will see is that there will be a paragraph in the agreement that says that the vendor or the supplier agrees to notify the customer in case of a breach, agrees to keep the customer's information secret, agrees to employ the security measures that are listed on Exhibit A. And Exhibit A might be 3 bullet points long, or it might be 40 pages long. Kind of depends on the industry you're in, who your customer is, what your capabilities are and resources are as the vendor. So contractual compliance is a big driver of security, but so is avoiding an incident. Because even if nothing gets out of your environment, you may still have had a contractual breach that you have to report to your customers. You may still have had a data breach if someone just gets in, even if nothing is exfiltrated, that has to be reported to consumers or to consumer regulators. It is expensive and time consuming to figure out if you've had a reportable breach, because you have to look at all the contracts and all the state laws. And you have to look at the facts. When did they get in? How long were they here? Did they take anything? What did they take? Those kinds of things. Countervailingly, cyber insurance, more expensive now than it used to be, still very cheap for the coverage that you get. Highly recommend. It is very easy in the face of an incident, whether it's a hack, an employee accidentally sends a file to somebody they're not supposed to, ransomware that shuts down your network and destroys your data, all of those things. In addition to the direct business costs, you're going to start paying maybe a PR firm, probably a forensic technology firm, probably a law firm. That adds up very quickly. It can also mean if it's something you have to report to a customer, they may have the right to cancel your contract. Obviously, also a suboptimal outcome. And I will just hear everybody, when we talk about security incidents, everybody has in their mind the image of the bad guy in the basement, hacker, or the bad state actor, right? Trying to sort of national terrorism, cyber warfare type stuff. That absolutely happens. It is very common. But the most common thing, and the thing I get called about most often, is what's called business email compromise, which is the customer sends an email to the supplier, the other way around. The supplier sends an email to the customer saying, hey, we've changed our bank account. Next time you pay a bill, here's our new wiring instruction. Customer says, okay, got it, thanks, and sends off a $40,000 wire or $1 million wire or whatever it is, and it goes straight to a bad guy account, who then absconds, and you can't get it back. I have seen those from $15,000 to $2.5 million. There is no case law that tells us whose responsibility it is to bear this. And so again, it is expensive and disruptive to figure out how are we, the two affected parties, the customer and the supplier, going to allocate this loss. Do I have to cut another check even though I wrote a check? Or do I have to lose my $1 million payment just because it got sent to the wrong bank? It's expensive and hard to figure those things out. Ransomware is the other one that tends to affect a lot of small and medium-sized companies because a lot of people don't have backup or business continuity in place. If your network gets locked down, it's much easier just to pay the ransom and hope you get something back. And that's exactly what they're counting on. So I will leave that there so that we have, I hope, some time for you. And it's very hard to keep lawyers on a timetable when the job is a clock. And so I will quit talking. Oh,
You can take it back there.
well, that's fine. The point was, you should hire a lawyer. And actually, in addition to the fact that it's a complicated, thank you, Linda. In addition to the fact that it's a complicated and technical area, there is a concept of legal privilege, attorney-client privilege. It is not as broad as we all would like it to be, and we tend to think of it as being, but particularly in the planning stage, less so in the incident response stage, when you are looking at your network and you're saying, wow, here is a list of 10 things that are problems. That is a $50,000 problem to fix. That is a $10,000 problem to fix. That is $1 million problem to fix. We can't fix the $1 million problem. We don't have those resources, but we can fix the $10,000 one day today and $50,000 one. All that discussion, all that risk assessment can be covered under an umbrella of privilege and therefore not available if you're sued or investigated if you are having that conversation with your lawyer and getting legal advice about how to measure those risks and quantify those risks. So that is the takeaway. Thank you, Alan, for talking. She's the young one. I know. No, younger than us.
So today I want to talk a bit about capital raising and the good practice for startup company in terms of capital raising. So there's many ways for a startup company to raise capital. And here are three popular securities you can offer to your investors, depending on which stage your company is and depending what the investor wants. The first one, we call it SAFE. It's simple agreement for future equity. It is essentially a contract between the company and the investor in which the investor invests an amount of money in the company in exchange for the right to convert the money to the company's equity in the future upon some triggering events. Those events typically include the next time you going the fundraising or acquisition. So this type of security can be really attractive for investors who are really betting on the long-term growth of the company, but may not be attractive for those investors who may have a more concrete timeline about your rate of your return of your investment. And the second one is we call it convertible note. It is essentially works as a promissory note payable by the company to the investor. So it is a note made by the investor, but the investor have the right to convert the loan amount to your company's equity in either on a future day or upon some triggering events. So the convertible note is a good option for a company. It is more developed, but wanted to raise a lot of money very quickly. Because to raise money through convertible note, it can be much quicker and much easier to propel than you go through the traditional capital raising through equity. The third one is the equity, which it's the ownership interest in a company. So if your company is a limited liability company, we talk about your membership interest. If it's a corporation, we talk about your capital stock or the shares. And you can sort of divide a few classes in your equity. So, sometimes we often see like common units and preferred units in the LLC. So the preferred units would have priority to receive distribution when the company has profits. So typically the preferred units would receive like a preferred return, you see like 8%, 5%, and then they get whatever they invested in their company first before the common units will have the opportunity to catch up and receive distribution from the company. So which one is the right one for your company? It really depends on which stage your company is in and what your needs are, and sometimes depends what your investor wants. So generally speaking, when your company is at an early stage and you wanted to raise small amount of money quickly, SAFE can be a popular choice. If your company is further developed and you want to raise larger amount of money, but also wanted to do it quickly, you can try convertible notes. The third one, it's more traditional fundraising process. You wanted to raise significant amount of money, attract private equity funds. They typically want to go through the capital raising through equity. The age doesn't really help. So when you get ready to raise funds for your company, there are a few housekeeping issues you need to pay attention to. So first one is to set up your company structure. Have you set up a company yet instead of just doing business as an individual? So whether to set up your company as an LLC or a corporation, you may want to talk to your CPA or an attorney to decide what's the best company structure for you, depending on the nature of your business. The second one is to maintain proper corporate governance document. If you are an LLC, you probably need an operating agreement, especially if you have multiple members in a company. Same with the corporation. You want to have proper bylaws adopted, and if you have multiple shareholders, do a shareholders agreement among the shareholders as well. And you have the shareholders appoint the directors appoint officers. Every director meeting or shareholders meeting, you want to have proper minutes and properly document those things that happen. Want to have a proper minute book, corporate minute book kept with your company, because can be a very important issue at a later stage when your company wanted to attract private equity funds. This is always an important issue that in the due diligence stage, so you want to have the documentation ready. So the third one is actually also related to the second one I just mentioned, which is to properly document the equity interest and other rights with respect to your company. So if you have multiple shareholders, do a shareholders agreement, or for LLC, do an operating agreement, because those agreements allocate the rights and obligations among all the owners with respect to either the management of the company and also the right to receive distributions from the company. If you wanted to issue any incentive units to your key employees, like Minori mentioned about sweat equity previously, you wanted to, whether it's a stock option or profit interest or anything else, you want to have a proper plan adopted by the company and do individual award agreement to each recipient. So this is often a very important issue in due diligence process when an investor wanted to either invest in a company or acquire the company. The last thing you want is to have email laying around somewhere from the founder of the company to somebody that say, hey, I give you a 5% interest in the company and starting from today, but you have no official documentation associated with it. And 5 years later, when you sold your company, and then a day after, there's someone knocking your door says, hey, I have the 5% interest in your company. You actually owe me money. And in a stock sale, the title, the clear title to your stock or to your units is actually like a fundamental wrap. So we negotiate in mergers acquisition, all those limitation to your indemnification liability. And for fundamental wrap, it's typically carved out from those limitations. You will be fully liable to the buyer for if the title is not clean. So the fourth one is to assign IP to the company. This is for companies who are technology heavy So you want to make sure got your inventors properly assign whatever rights he has in IP to your company. And if there is a trademark application or patent application is going to be filed and have your company as the proper applicant, it's better to have everything properly documented, assigned at the early stage, than 20 years later or 30 years later, you even cannot find the inventor anymore. So then once you take care of all those housekeeping issues and you wanted to find your desirable investor, the rule of thumb is to offer to accredited investors if possible, because that's gonna make your compliance with the SEC rules much easier. As we may all know that in the US, when you either transfer security or sell security, the securities are required to be registered with SEC unless your transfer or sale can fall under certain safe harbor or exemption under the SEC rules, like we usually hear about the 482 exemption and regulation D safe harbor. So if your investor is an accredited investor, there are way less in English we call hoop to jump through to be able to make your offering comply with the SEC safe harbor or exemption. And then who can be considered as an accredited investor? The SEC rule has a very, very long definition, probably 10 or 15 categories of what kind of investor can be considered accredited investor. So for natural persons, we typically see, assess their income, their net worth, or their knowledge, either by owning some sort of professional certification or you are a knowledgeable employee in some private funds. So you also need to make sure that you need to properly document the investor intake, what kind of steps that you have taken to verify that investor who say that they are accredited are really accredited. So in your subscription agreement documentation, we always have like an investor questionnaire, which you will need the investor to properly fill out, check the box on which category that they fall under to be able to qualify them as accredited investor, and the investor needs to sign that questionnaire. And you need to keep that signed questionnaire in your investor documentation as a record in case in the future there's any audit from SEC or other government authority. Oh, I think I did one more.
We're all equally expert in here.
Okay, I think I already did.
Yeah, that one you did. There you go.
Okay, okay, so this is actually my last topic. I want to talk a little bit about founder fees. This is actually very interesting because before, when I was preparing my presentation, I sent out like a group to our corporate attorney, say, hey, what's the question you think those startup guys may be interested to hear? And one of the lawyer, she's much senior than me, and she was, she said, you have to talk about finder fees with them because this is an important rule, but often, overlooked by people in reality. So we know a lot of startup companies work with a finder to find their investor, and also pay certain fee or compensation to the finder for their services. These are all fine unless the finder's activity constitute as broker or dealer activity under the SEC regulation, because the SEC requires any broker or dealer to be registered with the SEC, and only a registered broker or dealer can receive any transaction-based or success-based finder fees. So what is broker dealer activity? So I list out the bullet points here. one is to solicit investors or to assist in structured security transactions, to help identify potential investors and to participate in deal negotiations, or to handle investment funds or securities. So, sometimes if the finder did something that may, be considered as a dealer or broker, and you pay them a fee based on transaction or based on success, but such person is not registered with SEC, then will cause you to a violation of the SEC rules. And the consequences for that is, first, the offering might be considered rescind. To rescind means the offering can be considered void from the beginning, which may, the investor will be entitled to ask the money to be paid back to him or her. And also sometimes there might be interest imposed on the payment, on return of the payment. The worst, like the more severe scenario is the company may be prevented in further raising funds by relying on any regulation D, safe harbor, or 482 exemption under the SEC rules. So think about if you, like 10 years ago, you raised like $5,000 by pay the finder certain fees, and which was a SEC rule violation, but it may cause the danger for you to lose the capability to raise money in the future again. I think that's something that you want to think twice and pay attention to. Sorry, I have the very last one. So then what's the good practice when non-broker dealer finders are used? So two things is, first is to avoid any compensation arrangement tied to deal success, investment amounts, or other deal related factors. So you can pay them monthly fees, that's fine, not based on, whether the deal is gonna happen, or, your compensation is based on certain amount, the investment that you're gonna get from the investors. The second one is ensuring that finders do nothing more than make initial introductions. The finder hooks you and the investor up, and but do nothing more. They don't do any marketing or negotiating terms for deals. So that's all my presentation.
Cool, we'll start Q&A now. Awesome.
Oh, yeah.
Sebastian, do you want to call on people, or do you want us to call on?
Call to you.
Okay, so you're
Question for you, actually.
okay, sure.
Interest in tech. What would you recommend from a data standpoint on a cloud versus a internal storage?
I'm assuming you're talking about a third-party cloud service.
Exactly.
Yeah, so what you want to have, in that case, you're the customer, you want the vendor to be making certain representations to you about how secure.
Like, yeah, talking about compliance, I know where is that stored and how that's kind of navigated.
Yeah, you want to know where it's stored, because you want to know what laws are going to apply
Correct.
to it. You want to know, I'm sorry, am I not getting your question?
No, that's right.
Okay.
Yeah.
You want to know what data are going into the cloud. You may have some contractual requirements to keep certain customers' data logically separated. And so you may need to account for, do I need to have multiple accounts? Do I need to have the ability to logically separate? Again, I would think about business continuity and backup. How available is it if, bomb hits my building or hacker takes my network down?
That's what I was
Much
gonna
less
ask.
bad. Any of those kinds of things. I mean, in any commercial services agreement, whether it's tech-based or an independent contractor who really is an independent contractor, or you're hiring a broker dealer or whatever, your agreement is going to say, here is what the vendor is doing for you. Here are the standards under which they will perform it. Here are your rights as a customer. And here is the remedy if they screw things up, right? And what you want, particularly from a tech standpoint, is to understand what security are they using? Is it adequate to meet not only your business needs, but also any legal compliance needs that lay on top of that. And you need to have the business understanding of what happens if this goes down, what happens if someone gets in, or if data gets out, and what is my exposure in that case, and what can I look to them to do for me? Yeah, you're welcome. Yes.
So, we built a data privacy application, the first of its kind in one of the top 5 largest bank based on
Okay.
San Francisco, California. So, so when we built it, I mean, obviously we did a lot of research about GDPR, which the European law is about, and CCPA, which is in California.
Yep.
Right? So basically, we dig in and out of CCPA, what is GDPR, what is CCPA? So just to everyone know, right? So GDPR is something like that would cover an individual person, right?
Yeah, so
Is that right? And then the CCPA would be an entire household. Is that correct?
it can, yes. So the question is, what are the two sort of prominent laws that I talked about, the one in Europe and the one in California? Europe, you'll hear the acronym GDPR, General Data Protection Regulation is what it stands for. It was enacted by the European Parliament, it may be a directive of the Commission, I can't, anyway,
Yeah,
whatever.
commission.
But it was adopted then by the 27, 28 member states of the EU bloc. So it is EU-wide law, and it protects the data of people who are in the EU. Does not protect the data of EU citizens. It protects the data of people in the EU. So if you have an employee from the States who goes and works in France for a year, their data is now subject to the GDPR. There are no size thresholds for it to apply. There are no territorial thresholds for it to apply. There are no materiality thresholds for it to apply. If you are doing business in the EU, and you are collecting data about individuals, that data is subject to the GDPR. And fines for violating the GDPR can be assessed at up to 4% of the company's global revenue. And if the company is one of a set of affiliated companies, or has sister companies, parent companies, whatever, it is the global revenue of the whole organization, not just the little company, or it can be. CCPA is California legislature's effort to try to play catch up to Europe in the absence of a national US privacy law. CCPA is both more restrictive and less restrictive than the GDPR in some kind of confusing ways. It allows consumers to sue you directly if you violate the law in certain ways. It also allows the state regulators to come after you if you violate the law and fine you. The fines are not as eye-popping as the European ones are, but the lawsuits can be substantial. It has now been copycatted in some degree by, as I've said, approximately a dozen other states. But California is kind of the gold standard for US state-based comprehensive consumer privacy laws. And as the gentleman said, it can cover the personal data of individuals, but also households. So if you are inferring characteristics about a household, for example, we have a client that manufactures hot water heaters, residential hot water heaters. And like everything else you can buy for your home today, you can get smart ones that collect data. And so if that tells you that prime time for the household is 8 o'clock in the morning because there are 3 showers in a row, which you can deduce from the water usage, that may be personal from the household that has to be protected. So it's just, and anything, any smart device in your home is likely to be gathering personal information that is going to be regulated. In California, if you are doing business in California, and there are size thresholds there, but then there are these other states that now have consumer privacy laws that don't have size thresholds.
And also,
Did that
like,
answer?
yeah, so, I'm just coming to that question. So,
Sorry.
so based on, I think.
Told you it was hard to keep this quiet.
Yeah. Just to everyone who I'm just going a little bit in deep.
Okay.
Is, because any company which is headquartered in California, so they have on their website where you can go in, any banks, you can go in and fill up a form saying, tell me what information you have about me, right? They will send you a notification. That's what we built
Right,
for the bank, which is Wells Fargo.
right,
So tell me what information you have about me, which they will send you the notification, right? And you can call back again, say, hey, what information do you have about me? And delete the information about me, right? So the companies will have a minimum data and then they'll delete the rest of it.
Yes, and that is true in all of the states that have privacy laws, and it is true in the EU, and it is true in other jurisdictions, that the consumer rights, I said you need back-end processes to comply with what you say in your privacy policy. Part of what you have to say in your privacy policy now is you can contact us to delete your information, get a copy of your information, correct your information, whatever it is, and you have to comply with that. And in many cases, there's a timetable on how you have to comply. You cannot generally ask the consumer, you have to verify who they are, but you can't ask them for sensitive information to verify who they are. So, I mean, right, it is, the California legislation in particular is it's a terrible law.
Yeah.
It was, the GDPR came out, it had a 2-year window between when it was announced and when it took effect. California was looking at it. Everybody here has been lobbying Congress for 10 years to try to get a national privacy law. And somebody in California finally got sick of it and said, you won't write a law, we're going to. So they passed through the legislature and got signed by the governor, a comprehensive privacy law in a 10-day span in the month after the EU laws took effect. And so it was amended 3 times before it even took effect. It was that terrible. And it has now been amended by the voters once, and they have created a whole new agency to write regulations to carry out the law because the law is so terrible. Yeah.
So if the federal government comes up with a data privacy law, would that supersede the California?
Unclear and a big impediment to getting a law passed. That's a question.
Yeah, kind of going back to your presentation.
Yes.
The customer and the vendor, they wired money back and forth, right? They lost money. We have a similar situation, but we're a technology service provider. We supported our client the best we could, told not to X, Y, Z. They wired the vendor, they are a vendor, the client of ours, and then the client of theirs actually sent money, a little over $5 million, to the wrong party. And we're in kind of a similar situation. Because there's that third party that's managing the technology, obviously their client is saying, hey, you guys got to pay us back,
Right?
X, Y, Z, and we're trying to figure out, how does that work? There's no precedent for, reimbursing someone for not following their policies or procedures on their wire, their ACH, transfer, rules. What have you seen to help alleviate the situation?
So in those business email compromises, what generally happens is the parties settle. I will tell you that most of them settle it on roughly a 50-50 basis because there is very little case, there's no law like statute that applies to this. There is very little case law that applies to this. There are 3 very prominent cases that do not come out with any consistent result. Instead, what the judge did in each of them will say, let's look at the facts of this case. First of all, was it reasonable in the legal sense for the party that cut the check to cut that check under the circumstances? Did this email look real? Did it come from an actual domain name? Is it full of typos and spelling errors? Was it coming at weird, does it have weird timestamps on it? Those sorts of things. Bad guys have gotten better at it, but that used to be a pretty reliable way, right? So can you figure out who was hacked, if there was a hack, or who was spoofed? Did the company that paid the check make a phone call to verify the new instructions, for example? Does that company have an internal policy that says don't change payments without calling to verify? And did they violate that policy? So the court would look at all of those kind of facts and decide, was it reasonable to issue the payment faced with this email? And if it was reasonable, which party was in the better position to stop the fraud? And because that is going to be completely a he said, she said kind of, well, you didn't make a phone call. Yeah, but we weren't the ones that were hacked. Yeah, but, right. I have a client that just settled one of these. They sent 100 wires over the course of 4 weeks in response to 4 different fake emails saying, oh, here's our new account. No, wait, here's our new account. Oh, no, hang on, here's our new account. $2.5 million, 100 invoices, right? Idiots. That is bad form. But their system is clean. The other party was hacked. But my client is gonna pay another $1.7 million to settle this out of the 2.5, because they don't wanna take it to court. And so it would be those kinds of facts. And because it is such an uncertain, fact-driven, how do I feel, what do I think is fair in this instance? Most parties negotiate it, and most of them come out somewhere in the 50-50 range. This one is skewed in a way that is much more extreme than I've ever seen.
Two calls to make to your lawyer and the insurer.
Actually, first you call the bank and say, stop that payment. Because if you can get it within 24 to 48 hours, the FBI might be able to get it back.
Yeah, that's.
After that, it's gone.
Back, and then the banks obviously.
Right.
But it was.
The banks are
once it hit,
not,
it's gone.
and the banks are not going to carry the loss. That is the one legal certainty I can give you, is that it cannot be the bank's fault, even if it's the bank's fault. So, anyway.
That's
We'll
just-
do
it's just
one more
a-
question and see if we
But I have a question for a while.
That's it.
I forgot it. My question pertains to employment. What is your perspective on professional employee groups or PEGs? Pros and cons for small startups?
I think it depends on, I think where employees are based is probably going to determine what's useful for you or not. I have lots of employers, who are small, growing, and if they have, a good CPA, if they have a good bookkeeper, they can keep on top of most things. And sometimes there'll be opportunities with even I have clients who use ADP to handle everything. I have clients who use Insperity, and I have clients who use smaller things like JustWorks, etc. And they can provide the benefits as well. But they can also provide the tax and the payroll advice. I think once you start to grow and have people in different jurisdictions, I have clients who sometimes try and do everything themselves, and I think that's just too risky.
Well, I have one of those, and I am an LLC domiciled in the dreaded state of California. I moved to Georgia, back to Georgia to run business from here. So I have employees in California, employees in Georgia, and in New York, and I found it saved my life.
Well, that's the point though. As New York, you've chosen the two most difficult states, really, New York and California. And I mean, if you comply with California law generally on most things as the highest level of how you're going to treat your employees, you will generally be treating everybody else within other state laws.
And that is the rule that we apply even
Yeah.
in Georgia. We follow California law. And figure
Yeah.
it's, it's the most.
But they have, for example, different sexual harassment training requirements, and they're mandatory in about 8 states, and New York's one of them. But I think the fact that you're using somebody professional to help you is probably the best thing that you can do. That's where I see the mistakes happening, when it's somebody trying to do it themselves, and they don't register in the state, they don't get tax help.
Cool. We're running out of time. We'll do Sander Lab.
Super short, and another one from the north, who knew? So when those employees, this is a two-way street here, right? We went entirely virtual. Guess what? Like one day I would call up and somebody's moved to California, someone's moved to Florida. Is there a way to effectively stop that from happening?
What I've started to do is put in contracts, the location is in your, in the state of the residence that you notified to us, and the location that you gave.
But if you're in a right to work state like Georgia, can you do that?
Yes, you can. You don't have to offer anybody a job. You can say the terms of you being here are ABC, that you're residing in Georgia, and that the address that you give is in Georgia. We're hiring a Georgia employee. And in fact, I'm currently dealing with an employer that offered a job to somebody in Maryland, and the employee at the application stage gave a Maryland address. And then lo and behold, 10 days later,
Yeah.
he's moved to DC, which has more protective laws than Maryland. and, in fact, impact the salary that they would have to give them. And the client is calling me, well, what do we do about it? And one of the things you might have to do is say, well, you misrepresented where you lived at the time of hire. You know, why are you saying you were in Maryland if you're actually, you know, pretty much living in DC? But what you can do is, like I said, you're not obligated to offer anybody a job, so you can, you can say, you can ask them where are they living, and this is state, and it, as part of their job offer, it's you will be working at a location. Now imagine old school pre-COVID, there's the office, right? If you say you'll be working in the office and suddenly the person doesn't turn up, they're just at home, you would say you're fired. Your job was to be physically in the office. So just in that same manner, you can say you will be working from the residence in the state of Georgia that you gave, and you are not allowed to work outside that location without authorization.
Thank you.
All right, awesome. We're running out of time. I apologize. If you have a quick, you can do it.
Just a quick question. I'm in the IoT space, and fortunately, we have we have the benefit of having 2 in-house counselors. But what I wanted to ask you is, you know, we're looking for tax firm right now. So would you recommend somebody from a larger standpoint or a smaller firm? Because you know, tax law is so difficult, you know. I guess that's for all of you. I don't know if that, you know.
If you're talking about, just because my accent, I'm not from here, TAX, you're talking about tax.
Yes.
Okay, so I would say, again, it depends where your employees are. If all of your employees are in Georgia, for example, from a payroll employment tax perspective, you don't need to go to a big four place. You could go to a smaller or a medium-sized CPA firm to help you. If your employees are all over the place, you're going to have to get tax advice that's more complicated, and that tends to be from some of the bigger places. If you're selling everywhere, you're going to have a tax advisor that can advise you on state sales tax everywhere, which might not be one of the smaller firms.
I agree.
All right, awesome, guys. If you want to give them a round of applause.